Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast, the NJ Laws Tube, looking at recent cases by the New Jersey Supreme Court and Appellate Division, and in particular the cases that were discussed at the seminar handling drug, DWI, and serious motor vehicle violations sponsored by the New Jersey Institute for Continuing Legal Education. Let's see. We now look at a DWI case with expert witnesses. Can the court order the sequestration to apply to the defense expert? And the answer was no in State versus Pavlovich, no sequestration of defense expert. I'd say in this matter, the appellate division reversed the defendant's DWI conviction. I'd say they found the trial court erred when it ruled that defendant's expert was subject to a sequestration order. It would not permit the expert to watch the trial testimony. That was State versus Pavlovich. 405 NJ Super 324 Appellate Division 2009. Let's see. Now, can police always search a car that's stopped for a moving violation? And because there used to be an argument that there's community caretaking or automobile exception, and in a major Supreme Court case of State versus Penaflores, there's no automatic automobile exception. Now, the Supreme Court affirmed its long-standing precedent that permits an automobile search without a warrant only in case in which the police have both probable cause to believe that the vehicle contains evidence and exigent circumstances that would justify dispensing with the warrant requirements. Whether exigent circumstances exist is to be decided on a case-by-case basis with a focus on police safety and the preservation of evidence. The court also determines that a warrant obtained by telephonic or electronic means is the equivalent of an in-person warrant and does not require proof of exigent circumstances. That's State versus Penaflores, 198 NJ 6, 2009. Our next case deals with the United States Supreme Court. Should the police be able to search the passenger compartment of a car after the driver whose license was suspended is handcuffed and locked in a police car? And the U.S. Supreme Court in Arizona versus Ganson, no. No search of a passenger compartment of a motor vehicle incident to a recent occupant's arrest unless it is reasonable to believe that an arrestee might access the vehicle at the time of the search or that the vehicle contains evidence of the arrest. The guns were suppressed in this case, and that's Arizona versus Gant, 129 Supreme Court, 1710, 2009. Drug cases, constructive possession. What is constructive possession? Sometimes the police would argue that if you're in a car, that's constructive possession, but the New Jersey Supreme Court really said no. They said constructive possession is a decision by the trier of fact, not an expert. In State versus Reeds, the court wrote, such possession can be constructive, meaning that although the defendant lacks physical and manual control, the circumstances permit a reasonable inference that the defendant has knowledge of his presence and intends and has the capacity to exercise physical control and dominion over it during that span of time. That's State versus Reeds, 197 NJ 280, 2009. Let's see. And highway signs. Let's say the state does not produce evidence as to whether or not the sign was properly posted. Let's say, is there any sort of defense? And the answer in State versus Smith was no. There's a rebuttable presumption that a sign is properly posted. In this case, the defendant's conviction of a trial de novo for violating the U-turn statute 39:4-125 was affirmed because he turned his vehicle around so as to proceed in the opposite direction of the highway, in which a no U-turn sign was conspicuously posted. The defendant does not have to perform a full U-turn. And they also said the West annotated version of the statute contained an error. The no U-turn sign need not be on a state highway, and therefore whether or not the road was a state highway was irrelevant, as there was a rebuttable presumption the statute was properly posted. Also, Since the defendant was not entitled to assigned counsel, the fact that he was improperly assigned counsel law division does not require a vacation of the municipal court conviction because he was not assigned counsel there. That's State v. Smith, 408 NG Super, 484 Appellate Division 2009. For additional information, contact the law office of Kenneth Vercammen, 732-572-0500. More information on the web at www.njlaws.com. That's njlaws.com. And benotguilty.com. That's benotguilty.com. We're at 2053 Woodbridge Avenue, Edison, New Jersey, 08817. In future editions of NJ Laws 2, we look at other cases decided by the Supreme Court and appellate courts. Thank you.